I'm speaking to Jeremy Sirrell, partner at Palmer Solicitors and specialist in motoring offences. Jeremy, I want to talk to you about dangerous driving offences. So could you clarify first of all what constitutes as dangerous driving?
Yes, dangerous driving is an offence created by Section 2 of the Road Traffic Act 1988, which very helpfully tells us that dangerous driving is defined as driving which is dangerous. It's pretty clear that somebody thought that some more assistance might be needed because a little while afterwards a Section 2A was inserted indicating what the legislators thought was dangerous driving, and what the legislators think is dangerous driving is driving which falls far below that of the careful and competent driver, and where it would be obvious to a careful and competent driver that the driving was dangerous. Now, as a definition, that's fine so far as it goes. The difficulty with defining dangerous driving is that it lies on an unbroken line from, at one end, the most minor road traffic offence you can imagine, someone backing out of a car parking space and just touching another car, to at the other, a serious series of offences where there's a police chase, someone mounts the pavement, goes through a red light, travels around the roundabout a wrong way, and all the rest of it, and they're clearly dangerous driving. But there's an unbroken line from one extreme to the other, and at some point along that line, an offence of driving without due care and attention, or careless driving, becomes dangerous driving. But nobody really knows exactly at what point along the line that occurs. All we can say is dangerous driving is driving where the standard of driving falls far below that of the careful and competent driver. Who defines what is far below? Answer, the court does, which may be a bench of magistrates or a jury if you're going to be running a trial.
So if you're found guilty for dangerous driving, what are the normal consequences?
Well, the consequences can be very serious indeed. The maximum sentence of imprisonment for dangerous driving is 2 years, and indeed the courts will routinely jail those caught driving dangerously. There's a minimum disqualification of at least 1 year that must be imposed, and an extended driving test that needs to be taken and passed at the end of that. And normally a court would think in terms of years rather than months in terms of the dangerous driving disqualification.
Right, and this might be an obvious question, but why is it beneficial to seek expert legal help with a case like dangerous driving?
There are essentially 2 reasons why you should. The first is that dangerous driving in and of itself is clearly very serious. So even if you're going to just plead guilty, the nature of the matter means that you really should seek representation at an early time so you get proper advice. What are your options going forward? What are the likely outcomes, and what you need to do to face them? The second reason is because, as I've already alluded, dangerous driving is an offence which lies on an unbroken scale, and what the police may consider to be dangerous driving may not be considered by a court of magistrates or a jury to be dangerous driving. And dangerous driving, like careless driving, is also one of those offences where you might end up being charged with it because somebody in the police force decides that you are responsible for the accident, and you might take the view that in fact it's someone else that's responsible. Not as simple as that, of course. Dangerous driving by its very nature sometimes can be very complex. But these are all issues where you really do need to discuss it with someone who has some experience, so you can make a reasoned and informed judgment about what it is that you need to do.
Jeremy, thank you.